Good morning, everyone. My name is Helen Miller. I'm a Deputy Director at the IFS, and I am delighted to welcome you to this debate on how non-DOMs should be taxed. This is the latest in what is now quite a long series of tax debates that we, the IFS, have been hosting alongside the Chartered Institute of Taxation. And based on the huge number of sign-ups we've had, it looks like today's event could well be a record breaker for viewing figures, which is perhaps not surprising given that non-DOMs and how much tax they do or don't pay has been getting, I think, more attention in recent years. There have been some significant policy changes already, and the Labour Party have stated that if elected next year, they would look to abolish non-DOM tax status. So I suspect what many people listening to this event would like to know is what exactly is wrong with the current system for how we tax non-DOMs, and even more importantly, how should we tax people who live and work in the UK but don't necessarily see themselves as having a permanent home here? And to help you answer that question, I think we have the perfect panel. You are going to hear from, in this order, Emma Chamberlain, who is a barrister at Pump Court Tax Chambers and joint chair of the CIOT's Private Client Committee. From Nimesh Shah, who is CEO of Blick, Rothenberg, and worth saying that together Emma and Nimesh bring a huge wealth of experience with the tax affairs of non-DOMs. We'll then hear from Arun Advani, who is an associate professor at the University of Warwick and has been doing lots of great work looking at HMRC tax records to study how non-DOMs respond to tax. And then last, but by absolutely no means least, from Jane Page, who is currently a tax advisor at Kirk, but until very recently was an HMT policy advisor, so has been directly involved with making policy for this group. Each panelist will speak for around 10 minutes or so. We'll then come back together for a discussion, during which I will put some of your questions to the panel. So if you have a question, please pop that into Slido, the link for which you were sent alongside the event email. And do, if you want to, upvote which questions you would most like to see discussed. For now, I'm going to pop into the background and enjoy the event. I'll pop back at the end to chair the Q&A. For now, let me give the floor to Emma to kick us off for today's debate. Thank you.
Good morning, everyone. I'm going to spend the next quarter of an hour discussing domicile and residence, because I've been asked to explain the difference between them. So if I can get the slides to move on, which is difficult, that's it. First of all, what is the difference between residence and domicile? People are often confused by the concepts. You can be resident in this country and not domiciled, and you can be domiciled in this country and not resident. What do the concepts actually mean? How does the UK tax arrivals and leavers at present? What connecting factors are currently used? What's the issue? Why are non-DOMs different? Why do we need to tax people who first come here, arrivers, and those who leave, leavers, differently from everyone else? And I think it's probably helpful to know what other countries do. So what's the difference between residence and domicile? First of all, you can be tax resident in more than one country at the same time. That's why we have double tax treaties. But you can only have one domicile in a country at any one time. And residence broadly is, where are you living right now? So the UK test is if you're here more than 183 midnights, you work full time here, you're only home here, any of those, you will basically be UK resident. But there are exceptions. So a new arriver could be resident even if here for only, say, 91 midnights, depending on their other ties here. So family, accommodation and work. And broadly, it's a ladder. The more ties you have, the fewer days you can spend here. If you've only got accommodation here, you can spend much more time than if, say, you've got family, accommodation and work before you become UK resident. Since 2013, we've had a statutory residence test, and we now have pretty much reasonable certainty on when someone is resident here. But by contrast, domicile is a very much more elusive concept. And if you're really interested in this subject, there is a CIOT explainer, which I've put on the slides, which will be sent out after this talk, and you can go and have a look at that. As I've said, you can be resident here, but not domiciled here. And remember, you're not domiciled in the UK as such. Under our common law, you're domiciled in a country. So it's England and Wales, Scotland, but you're not actually technically domiciled in the UK, although we often use that as a shorthand. You can be resident abroad and still domiciled here. So, for example, if your domicile of origin is England, you were born here, your parents were English, but you go abroad and you've not formed an intention to settle anywhere else permanently, and maybe you travel working in various different places for the next 20 or 30 years, you do remain domiciled here, even if you've not set foot in the UK for years. And that's often quite difficult for people to understand as well. You're normally regarded as domiciled in the country in which you have your permanent home or chief residence. And those sound easy, but they're not defined, and they actually become quite difficult concepts. And it's compounded, the complexity, by the fact you may be domiciled in a place you have no home at all. For example, your domicile of origin is usually determined by your father's domicile at the date of your birth. And I think it's probably easier just if I give an example of this. I can get to the next slide. Alfred was born in England in 1940. His parents are English domicile of origin, easy. 1960, he emigrates to New York and he marries and works there and has a child, Troy, in 1970, at which point he moves to California. Now, for the next 30 years, Alfred moves between different US states, each time for work purposes. And finally, he retires and he moves to Florida and he ends up dying there, and he never returns to the UK. So where is Troy domiciled? Might be relevant because Troy comes to the UK, for example, for a work assignment. Now, you would think Troy couldn't be domiciled in England. He's never lived here. At the point he was born, his father, Alfred, had been domiciled, had been resident in the US for over 10 years. But actually, given Alfred was not settled in any particular US state, you can't be domiciled in a state, you have to be, in the US, you have to be domiciled in a state in the US. Given he moved between different states until he finally retired to Florida, Alfred never acquired a domicile of choice abroad. His domicile of origin remains. And that means that when Troy was born in 1970, he took an English domicile of origin. And you might think that was, or he might think that was rather odd. But unfortunately, that will be the position for him. And it probably won't matter for him greatly unless he came to live in the UK, at which point having a domicile of origin in England would make a big difference. So you can see immediately the problems around domicile. It's a test based around intention, which is hard to police and often misunderstood. And the problem is intentions change imperceptibly over time. It's based on traditional relationships, which are now less current. For example, if you're the child of a same-sex relationship where your parents are married, you wouldn't actually be able to determine your domicile under common law. It's also based around the concept of having a chief residence. So if you want to acquire a domicile of choice abroad, the Law Commission defines it thus. If you've got a domicile of origin, let's say in England, and you want to acquire a domicile of choice abroad, you must both reside in the new country with an intention to make your home or chief residence in that country permanently or indefinitely. And residence, by the way, doesn't mean tax residence. It means a chief residence or home. So let's say the typical foreign dom banker who comes here for a time-limited purpose, tends to work here and then intends to leave in due course. His domicile of origin will remain, he won't have acquired a domicile of choice in the UK. But as I've said, it is a test-based intention, which is hard to police because intentions do change. For example, your banker might come here for 10 years with the intention of working here, and then he goes, he marries, he settles here. He's been here 20 years before he knows it. His intentions have changed imperceptibly. There was no one point in his mind when he said, I'm settled here, but in the end, he is settled here. And that is quite difficult to police. As I've said, it's based around traditional relationships. It's based around the concept of having a chief residence, which is hard given international mobility. And it also leads to lengthy arguments and uncertainty for taxpayers because the revenue are basically trying to police subjective intentions, and that's quite difficult. So we've got an increasing body of tax case law, and that obviously causes problems for the HMRC and also genuine uncertainty for taxpayers, who often find the concept quite hard to understand. So the government, in an attempt to simplify in 2017, ended up introducing a concept of deemed tax domicile, broadly, if you've been here more than 15 years, been resident in the UK for 15 years, whatever your actual intentions, you're deemed domiciled here for tax purposes. So we call it a sort of 15-year test. But even that isn't straightforward. We've actually got 4 different types of deemed domicile for inheritance tax purposes, and 2 different types of deemed domicile for income tax and capital gains tax purposes. And all these different types of deemed domicile operating in different ways suggests that maybe the concept isn't entirely satisfactory. So what does the UK do? What breaks does it give foreign doms? The aim is to be fair to those who are not here on a permanent basis. So if you're foreign domiciled and UK resident, let's take the banker who comes here maybe for a work assignment for a fixed term of 5 years, say. The idea is you only pay tax on your UK income or gains. So the banker will pay tax on all their earnings in the UK, but you won't pay tax on your foreign income or gains. We call those FIGs, which are provided they're not brought or remitted to the UK. So if you keep your FIGs, your foreign income or gains abroad, you won't pay tax on them. And thus the UK does give a tax break for certain types of new arrivals, but only certain types of foreign doms. It doesn't give a break for someone who might be born here, leave for 20 years and then comes back. Those people don't get any particular tax break. They're taxed on a worldwide basis the moment they arrive. You can see that the remittance basis, the idea that you only pay tax on foreign income and gains if you bring them into the UK, tends to discourage spending and investment, because why would you bring your foreign income and gains and invest them here if you're going to end up paying tax on them? It also leads to a lot of complexity, for there are lengthy rules on when income can be treated and gains can be treated as brought here for tax purposes. And we have codes of legislation on this. It also, I guess, benefits the wealthy with foreign investment income or gains. If you're a valuable worker who comes here and doesn't have a lot of foreign investment or income or gains, then the foreign dom status isn't really much use to you, at least initially. So it's really for, we target our reliefs basically at the wealthy who've got foreign investment income or gains. And that's in contrast to other countries which are more focused in some ways on getting workers to their country and giving them certain tax breaks for a limited period. I haven't even mentioned trusts and IHT, inheritance tax. I've been banned from doing that, but there's an even more complex position on trusts and inheritance tax that's evolved over time, which means that all those rules I've talked about are modified if you've got a trust and in relation to inheritance tax. So if we're not going to have domicile, we clearly need some connecting factors. So what could we use? If we're not having domicile, could we have residence? Well, if you're resident here, you pay tax. Could it be that the longer you're resident here, the more tax you tend to pay and it's phased in? Or could it be citizenship or some combination? But certainly if you abolish domicile, you will need to consider what other connecting factors can be used. And you may think that you want to differ between taxes. So, for example, you might say that someone who first comes here maybe does pay tax on their worldwide income. But for inheritance tax, it would seem to me to be rather odd to say that someone who comes here and perhaps dies a month after first becoming UK resident should pay inheritance tax on their worldwide estate. That would seem quite odd. And so you might want to have some phased introduction for inheritance tax at the very least. And similarly, what about the person who dies having moved abroad, perhaps a year after they've lived in the UK all their life? Do we want them to escape all inheritance tax? Currently, that is not the position, but would we want some sort of tail for those people? So options for other countries, Canada operates a rebasing, doesn't have inheritance tax at all. And when people first arrive in the country, all their assets are rebased at market value. And when they leave, there's an exit charge. Some countries, as we'll just see very quickly in a minute, have an impatriate time-limited regime and an exemption for time periods between 5 and 10 years. And you could have a phasing in of tax charges. So you could have IHT phased in over time. You arrive in the UK, no IHT on your foreign assets for the first 2 or 3 years. And then gradually it's phased in over time, with the rate maybe reaching the full rate after, say, 10 years. But you are going to have to think what reliefs for what taxes and how long should they last. I've briefly outlined on the slides what other countries do. Spain very much targets employees. So if you're a worker coming to work as an employee in a Spanish company, up to 600,000 euros of your employment income is taxed at a lower rate, 24%. Italy, there's a 50% exemption, and France has a similar exemption for bonuses, overseas work, and some exemption for foreign income and gains and wealth tax. So, and the Netherlands has what we call a 30% ruling. So 30% of your income of employees newly arrived in the Netherlands can be exempt. You can elect into that regime. So these countries are very much focusing not on the wealthy with foreign income and gains, but much more on workers. And that may be something we want to think about. So just to finish, really, best options. I think political stability is required. And that really does mean some sort of political consensus. So it would be good if all the parties could agree on what they want to do and who they want to encourage to come here. Generally, I think time-limited simple exemptions are better than a series of complex reliefs which overpromise and underdeliver. And I do think our current system has some considerable difficulties, both in compliance and policy. I think a phased approach of taxes increasing the longer someone is here may work best, but keep it simple. And Labour are definitely going to have to think about inheritance and trusts if they abolish foreign domicile status as a connecting factor. So that's me done. If I can hand over to Nimesh now, I'll stop sharing and turn my video off. Thanks very much.
Good morning, everyone. I'm Nimesh Shah. I'm CEO of Blick Rothenberg. What I'm going to talk about over the next 10 minutes or so will be a bit of a history lesson about the non-dom regime. Emma's very clearly explained about what the non-dom regime is, how it differs from residence, but in the context of what we're facing right now around the debate of whether the UK should abolish its non-dom regime, what the alternative may be, I think it's worthwhile providing some context that's happened, certainly in my time in working with non-doms, which has been over 20 years. If we go right back, and I haven't been practicing tax this long, but when income tax was first introduced in the 1800s, residents were only taxed on income arising abroad to the extent it was received in this country. So that was the real first incarnation of what we've got right now about this concept of bringing money into the UK. But it was only until 1914 that the remittance basis was formally introduced for those residents who are not domiciled and not ordinary resident in the UK. Lots of time passed, and then in that particular tax regime remained in broadly the same form until 1988, when there was a consultation document published by the government around the scope of the taxation of non-domiciled individuals, and whether actually domicile itself was a concept of determining a liability to income tax. So this goes back almost 40 years ago now, that this debate first started back then, that is domicile a very archaic concept that many countries in the world don't really understand, find it very confusing when compared to residency, as Emma was saying. Is this right as a taxing basis in the UK? Now, that consultation also highlighted some defects around the remittance basis, what the scope of remittance should be, artificial arrangements. The legislation was much broader back then in terms of, or much limited in scope, I should say, around what was a remittance to the UK. And people could, well-advised non-doms could certainly remit offshore income to the UK without a remittance arising. But none of that came to fruition through this consultation. But what has happened since in the early 2000s is the concept of domicile, the fact that someone of overseas origin escapes UK taxation by simply leaving money abroad. This was brought into public prominence, and I suppose there's a bit of a link there with what's happened recently with the Prime Minister's wife and her non-dom status coming under the spotlight. So in 2002, there was a very public case with Mohammed Al-Fayed, who Mr. Al-Fayed sought judicial review around the revenues decision around a forward tax agreement. What he essentially did was he agreed a tax-based fixed sum basis around remittances of foreign income, rather than make actual declarations of remittances to the UK. So this was incredibly public, high-profile individual. And that prompted then some further scrutiny because of the public attention from the government around what the residence and domicile rules should look like. And then there was another consultation document in 2002. Really, nothing happened in that intervening period. But then I suppose we had a cataclysmic rewrite of the non-dom rules in the run-up to the election in 2008. Now, in the autumn statement of 2007, before the election, the political parties, the opposition parties, the Conservatives and the Lib Dems, put forward a basis of charging a flat sum for non-doms, which is really now what we have with the remittance basis charge. No one was really expecting a pre-election type budget, but we got one, and Alistair Darling made a big rewrite of the non-dom rules back then, if you can remember that far back. I certainly remember it very fondly. It was a very intense period of about 4 or 5 months where the legislation wasn't just as simple as introducing a 30,000 charge. There was a huge rewrite about the offshore trust rules, which Emma touched on. And at one point during that process, the offshore trust was dead. Now, around the offshore trust rules, what happened was there was a relaxation very, very late in the process in 2008. I think almost sort of 2 weeks before when the finance bill came out, that offshore trusts would still remain a planning tool for non-dom individuals, albeit they weren't as generous as what they were pre-2008. Essentially, one of the things that I mentioned in the pre-2008 rules was that non-doms, through quite basic structuring, either through a concept called source ceasing, which I won't spend any time on today, but it essentially allowed non-doms to bring offshore interest into the UK by closing a bank account, but also offshore trusts, whereby non-doms could take a capital distribution out of offshore trusts and clean that money and bring that to the UK. The 2008 rules changed all of those rules. It broadened the scope of what a remittance is. It changed the offshore trust rules so you couldn't bring money into the UK, and it introduced that 30,000 charge. You would think that that was the end at that point, but what I saw thereafter was basically annual changes to the non-dom regime from 2008 onwards to where we are right now, and also a different tone, I suppose, from HMRC around how they interacted with non-doms, the inquiries that were raised. So briefly just cantering through what happened around the mid-2000s. So in 2009, the DOM 1 process, so this was the process that HMRC would effectively give a ruling on whether someone was domiciled or not, that was abolished. We did see a greater spate of inquiries after 2009. The tax return itself, so the reporting requirements for a non-dom changed. So the non-doms would have to declare and elect for the remittance basis. Actually, this happened a little bit before in 2005-06, but there was a specific section of the return which obliged a non-dom to put more information about their domicile status into the tax return itself. We have to remember the context as well of non-doms. Part of the attractiveness of the UK, rightly or wrongly, for non-doms was the limited reporting that was required on a personal tax return. People would see the UK as being a safe place where wealth was welcomed, and part of that was in a home country, non-doms would fear that actually their data, their information would be leaked into the public eye, and that would be potentially threats on their lives and their families as well. So there was a real attractiveness around the limited reporting that a non-dom would face from a UK perspective, from as far as HMRC were concerned. In 2011, we saw the first increase of the remittance basis charge. So a new higher category of remittance basis charge was introduced, and it was set at 50,000 for non-doms that were resident for more than 12 out of 14 years. It's important to note, though, that the non-dom period at this point was indefinite, and as part of the 2008 reforms as well, that you could elect to claim the remittance basis by paying the fee, back then 30,000, but then increased to 50,000 from 2012, but you'd have it for an indefinite period of time. And I think there was a little bit of tension around that when the 50,000 rules came in. But crucially, and a welcome move in 2012, and I don't know if this was prompted by the fact that some of the loopholes, in inverted commas, were closed as part of the 2008 reforms, but something called business investment relief was introduced as a means for non-doms to use their offshore income and gains and remit those to the UK for a qualifying business purpose. Business investment relief was designed to be purposely very broad. It was intended to be very simple. However, as with a lot of legislation that we have in this area, it's viciously complicated and there are bear traps. And I suppose non-doms at this point were quite sceptical about bringing money into the UK, having to report those remittances as well, and the companies that they'd invested in. So my own experience of business investment relief is it's not that well known. Non-doms are sceptical of that relief in particular and how that information is going to be used around more disclosure. And the take-up of that scheme has not been, I suppose, as prominent as one would expect when it was introduced. Again, during the mid-2000s, post the 50,000 in business investment relief come in, the tone again from HMRC was certainly that there was more communication to non-doms. In 2014, there was an unexpected HMRC clarification around the use of collateralized loans against offshore income and gains. This was a technique that was thought to be widely accepted by HMRC, stated in its guidance that a non-dom could take a secured loan against offshore income and gains and bring the loan freely to the UK for spending in the UK, as long as the loan itself was not serviced out of offshore monies. That clarification from HMRC was essentially a reversal of standard practice and meant that many non-doms would have had to have restructured those loan arrangements. And I suppose it was an incredibly frustrating time for non-doms and their advisors and their banks who advised on such loan arrangements through HMRC guidance. The autumn statement of 14 then announced the 50,000 would go to 60,000 and a new category of remittance basis charge would be introduced at 90,000 for those non-doms that have been resident for more than 17 out of the last 20 years. And these measures would take effect from April 15. But what we had then was another election and actually, so crucially as well, just let me go back a point. In the autumn statement of 14, there was also a proposal to make the remittance basis mandatory if you claimed it 1 year for 3 years. That fell away completely, but the sentiment for non-doms was that someone would be facing a cost of up to 180,000, that new 90,000 charge, if that 3-year minimum rule had come in. It wasn't. We had a budget in summer of 15, and that introduced again the biggest rewrite of the non-dom rules since 2008. Now, this rewrite was prompted essentially by election promises from Ed Miliband at the time in opposition, in the Labour opposition, to say that Labour would abolish the non-dom regime. So very, very, again, set the sentiment from Labour back then, very similar to what we're facing now and what I suppose what we were facing with Jeremy Corbyn and John McDonnell in 2019 as well, that the non-dom regime would be abolished. I suppose what I'm trying to say is we have been here before, going back to the late 80s as well. And the non-dom changes in 2015 that were announced but didn't take effect from 17. Again, a hugely frustrating period in terms of the legislative drafting of that, the process that around it, the various consultations that happened. It was a big rewrite. But what this did was put non-doms on a position of a cap. They would only be able to claim the remittance basis for 15 out of the past 20 years. The 90,000 charge would only live for 2 years. That was introduced at the autumn statement of 14, and that would fall away. So non-doms would now have a free pass for 7 years. They would pay the 30,000 charge for the next 5 years, and then beyond that, it would be a 60,000 charge. And at year 16, at the start of your 16th year of residency, you would fall into being for tax purposes, deemed domiciled for all taxes. The 17 rules did introduce a relaxation to offshore trusts. So we did have a change in 08, as I said, and then in 17, offshore trusts actually became slightly more generous. We could talk about this all day, but essentially it switched off some of the attribution rules of income back to the non-domiciled settlor. So, and we introduced, and the concept of a protected settlement was introduced then. So with, again, structuring around using offshore trusts, non-doms could efficiently structure their wealth through one of those vehicles, and ability to then actually remit money back into the UK through the forms of loans or repayment of loans, depending on how those structures were established. Where we are, I suppose, now is, and I hope that sort of coming to the end of my part before I hand over to Arun, is that, as I said, I think that we have been here many times before around the reforms to non-dom legislation. I think the period of the last 12 years, 13 years in particular, has seen huge amounts of change, while small changes, but regular change as well, which has frustrated the non-dom community and also us as advisors as well. It's not the sort of work that we necessarily want to be doing. We want to be able to plan with certainty around what the tax legislation will look like. I do agree that the concept of domicile going back to the late 80s is a very archaic concept. And even now when I see people coming into the UK and try to explain the concept of domicile and its relevance to tax, you do get shrugged shoulders and a complete lack of understanding on what these rules mean, and let alone talking about remittances into the UK. I would say that, and we'll come on to maybe the debate towards the end, facilitated by Helen, but we do need a form of regime which still encourages investment and the right wealth into the UK. I do stress that phrase very, very carefully, that the non-dom regime has maybe attracted some bad wealth into the UK. We've had those documentaries from Panorama around certain forms of money routed through London and the UK because we have a limited reporting regime, and people have taken advantage of that. So I think a system around a residency-based test with a limited scope non-dom type regime, and also the concept of a remittance and mixed funds. We haven't even really talked about that too much, but the complication around different bank accounts. If we can remove some of that complexity, then there is a massive opportunity, I would say, and going back to what Emma was saying, if this can be cross-party consensus around what a non-dom regime should look like and an alternative to it, there is a huge opportunity for the UK to attract that right type of wealth whilst having an incredibly competitive tax regime. That's everything I want to say. I know I've taken people through almost 200 years of history there. I will hand over to Arun to talk about where we are right now on data and what the non-dom regime actually means. Thank you.
Great. Thanks very much, Nimesh. So I'll sort of briefly, given what you've heard from Emma and from Nimesh, I'll briefly take you through some of the key facts about the regime in terms of just what do we know quantitatively about who is making use of the regime. Then I'll talk a bit about what we think of the high-level problems, like what are the big picture issues here, because there's lots of detail in what both Emma and Nimesh have given you. So I'll zoom back out a bit and try to give you a high-level view of that. I'll talk a bit about what might happen if we were to just abolish the regime. And then I think, as both Emma and Nimesh stressed, we are going to have to think about what any kind of new regime looks like. What do we have in place afterwards? And I'll talk briefly about that at the end. So first, just quantitatively, who's affected by this regime? So as a share of the population, non-doms are pretty small. So this is just showing you over time, going back sort of almost 20 years, or going back about 20 years, and kind of coming forward, what do we know about the number of non-doms in the UK? That blue area is showing you the number of people who are claiming the status themselves in a given year. The green area above that is showing you people who at some point have made use of non-dom status, but are not claiming it in that year that we're looking at. So if you look at 2018, right at the end of this period, you can see there's about 60,000 people. So that's about 0.1% of the population who this is directly affecting at that point in time. But there's about twice as many more people who are no longer claiming that status, but who have made use of it in the past. So that just gives you a sense for how many people we're talking about. It's pretty small. But it's an important group in the sense that these are very high income and high wealth people. So this is just showing you across different levels of income, what share of people either are currently making use of non-dom status in a given year or have at some point made use of that status. So if you take that group all the way over to the right, you can see that for people who have incomes above 5 million, so it's a very small share of the population. But among that share, a third of them are at any point in time making use of this status. Actually, getting on even for another 10 percentage points of people have at some point made use of it, but are not up in that group. And you see that this kind of very clear trend that the share of people who make use of the status rises very quickly across the distribution of income. So high levels of income, this is a really important issue. And given that we know that in the UK, a lot of income tax certainly is paid by high income people, we do need to think carefully about how we design a regime that's going to affect this group. So what are they doing? Where does this money come from? Quantitatively, non-doms are workers. I mean, that's really where the money's coming from. I think what Emma and Nimesh said is exactly right, that the tax break that you're getting, the main tax break that you're getting on terms of the remittance basis, is against your wealth that's abroad and the returns from that. You obviously have this additional tax break on inheritance for inheritance tax purposes. But actually, most of the people who are using non-dom status are not the kind of your picture of someone who's high wealth coming here just to live here and not do anything else here particularly other than live off that wealth. I mean, you can see a very small group down at the bottom, this very dark red group, who are the ones who actually report they have zero UK income at all. So they're purely living off, presumably, the stuff they're bringing in from abroad, often bringing in capital rather than income, so they're not having to pay a charge for the remittance. But this blue area is showing you people who are employees, the green is people who are self-employed, the yellow is partners. And so that group, over time has been, between 75 and 70% of all of the non-doms at any point in time are in one of those groups, so are here working rather than are here as investors. One thing that I think is actually interesting is there's a growing number of non-doms who are actually pensioners. It's more than 10% now who are actually here, but their main source of income in the UK is that they are drawing a pension. And what are they doing for all these non-doms who I've told you are working somehow? What are they working in? Probably not surprisingly, and certainly in line with the example that Emma gave earlier, finance and professional jobs are really where these people are located. So the biggest industry that people are in is banks. So 11,000. I told you there's almost 60,000 non-doms at a point in time. 11,000 non-doms are in banks. So it's a really large share of them are picked up in that industry. And then a lot of other finance type industries are here. So financial intermediation, fund management. There's a lot of that sort of finance and city jobs. That's really what's driving quantitatively who these non-doms are, what they're doing. This is what they're involved in. So given that kind of background to who they are, what do we know about the regime in terms of what main problems are? I mean, the first problem is that, notwithstanding the business investment relief regime that Nimesh explained is pretty hard to use, the current structure strongly discourages non-doms from investing in the UK. So this is just showing you what's the share, what's the returns they get from investment, these non-doms, in terms of income and capital gains that's in the UK. That's that reported bar over on the right-hand side. And what's the bit they don't have to report, the bit that's foreign, that they're earning abroad. Well, you can see there's about £1 billion of income and gains that they're reporting in the UK. But there's, getting on for 11, so more than 10 times as much that's abroad. So this regime is really strongly discouraging people from making investments in the UK. And naturally it would. If you tax somebody for investing in the UK, but not for investments they make abroad, it's not surprising they would choose to make their investments abroad. But that's presumably not what we want from the perspective of UK policy. Other kind of consequences of the current design of the regime, well, it also discourages spending. You pay the tax if you bring onshore the income and gains that you make offshore to be able to spend them here. And so naturally that discourages people from spending in the UK. It also, in principle at least, requires some credibility to the claim that you're going to leave. If you end up having as Emma said, your chief residence becomes the UK and you really don't have any connections elsewhere, it's pretty hard to claim you're still not domiciled in the UK. So you have to keep some kind of credibility to that claim that you'll move. And the risk, for the UK is that, people keeping that claim alive, keeping a home, keeping a base, keeping some connection somewhere else. Maybe at some point we've attracted this talent, but they want to leave again because it's easy for them to do so. If we didn't require that, if we didn't encourage that, people might move here, set up shop here, enjoy their life here and say, actually, I'm settled and I don't even need to keep all of that open. And then they're less likely to leave later on. So that also seems like a suboptimal decision in terms of design. Emma's already set out the kind of problems around uncertainty and the difficulties of trying to really unpick, where are you domiciled and try to, figure out what someone's location is. It's a very nebulous concept. It's very hard to just look at it and go through a flowchart and say at the end, here's where you are. And that makes it, some of the court cases around this very difficult. And finally, there's a kind of unfairness. And this is both the kind of vertical unfairness that, as you saw, this regime is something that benefits people, particularly with very high levels of income. And so that can reduce their tax rates quite a lot compared to people who are further down the income distribution. So that's a kind of vertical unfairness. There's also a horizontal unfairness among people who are, for example, looking at banks that I described earlier. 1 in 5 bankers who's earning more than £125,000 is making use of non-dom status. So, in a meeting of 5 bankers, 4 of them are paying a higher tax rate than this 5th one who has the benefit of a special regime. Question, is that something we want? Is that something we think is a good design for the system? Do we think it feels fair to everyone in that group that some of them are paying a lower rate than others? So those are all kinds of things, I think, that lead people to move away from the current structure we have. So one question is just, suppose you abolish the regime. What do we know about what the impacts of that are? We don't know in terms of abolishing the entire regime. We've never done that. We have, as Nimesh described, had these reforms that took place that were implemented in 2017 that set some people as deemed domicile. That meant they were, for tax purposes at least, treated as though they were UK domiciled. And so what happened when we did this reform? Well, first you can just look at what happened to income. So the orange line here, this is looking at 2 different groups over time. The orange line is showing a set of people who are similar to the non-doms, but they are non-doms in fact, but they haven't yet reached the point in time where they're affected by this new reform, that 15-year reform that kicks in when you've been here for more than 15 years. And you can see that over time, this is you can see a kind of flat pattern in terms of what's happened to their incomes over time. The income level is somewhat higher for people who've been here longer. You spend more time here, you're a bit older, your incomes level go up. That's not that surprising. And what you can see really clearly is, as a result of this reform, just when this reform happens, you see a big jump up in terms of the amount of taxable income that people are reporting. So it went from a bit more than £1 million to getting on for £1.5 million of taxable income that the average person in this group is reporting. So there's a lot more money that's being reported in the UK. And unsurprisingly, that feeds directly through into tax paid. So that their tax paid also rose by about 36% compared to incomes rising at 38%. So you can see this in terms of the numbers. This is literally, you see the money coming in. These people are in the data, they are reporting, and this is what you see happening. So this is really exactly what happened. Now, a natural question is, but perhaps some of them would leave. So this is what happens to the people who are still here. But what happens when some people also choose not to stay here? There certainly were some departures. So this is just showing you now who reported still being tax residents. So again, defining these groups, looking at them over time, and looking at what's the probability that somebody who was in the UK as a tax resident in 1 year and a non-dom is still here the year after. Again, the level for the treatment group is lower. They're less likely to leave in any given year because they have been here longer and so they are more settled. But what you see is that after the announcement of this reform, and then when the reform comes in, there is definitely a rise in terms of people leaving. So removing this regime did definitely affect people's choices of where to be. This is about tax residents, so it doesn't mean that they've completely left the country. It just tells you that they are now here for few enough days that they are able to be below the statutory residence threshold. We're doing some work, which is not yet publicly available, documenting what exactly you see happening here. But this is not telling you these people have severed all ties and moved out of the country forever. It's just telling you that they've moved to a situation in which they are not tax resident here. And on the one hand, this is big. This is a big change from about 4% of people leaving in the early period to about 10% towards the end. On the other hand, what you see is that most people still aren't leaving. And the people who do leave, when you look at which kinds of people it were that moved out, or moved out from a tax perspective, it's the people actually who were least likely to be working in the UK and least likely to be paying substantial levels of tax in the UK. So it's the people for whom this regime meant they were close to not having to pay much tax, who were most affected. And so unsurprisingly, they're most likely to leave. But in terms of the financial cost to us, the cost of that's pretty low because they're the people who are already not paying very much in terms of tax. So what does that mean? I've shown you kind of who these people are, and I've talked to you a bit about some of the problems of the regime. If we were to go as far as abolishing the regime altogether, removing both the remittance basis and domicile as a connecting factor, we'd have to think about what we want the tax regime to look like afterwards. So Emma set out some of the options already a bit, but I think the key question is, do you want, if you're not going to have domicile, do you want residence? That's what a lot of countries have. That's what most countries have, in fact. You could have citizenship. That's what the US does, and Eritrea. Residence seems like the most natural thing to do because it's what a lot of other countries do. We might then want to think about exactly how that residence test works. Is it strict enough? Is it too strict? Where do you want to draw the line? I think that's one of the questions we'll have to decide is, how do you draw the line to determine whether somebody should be covered as a resident in the UK and over what period of time. The period of time is important because of this point around different taxes. So the test that we have for whether you are taxable in the UK presumably will differ by income tax versus capital gains tax versus inheritance tax. Emma set that point out already, so I won't kind of labour the point. But I think, in terms of what do I, at least for now, think is probably my kind of preferred direction of reform. I think for inheritance tax, I think you surely want to have people not in the regime initially when they arrive, and presumably to smoothly step up into the regime. So if we keep a 40% inheritance tax rate, you might say that for some number of years you're not in the regime. So say, for 4 years you're not in, and then over the next 6 years you get kind of 1/6 of that tax rate gets added on, so it gets to 40% only after 10 years or something like that. But you want something smooth like that, so there isn't a sharp cliff edge where somebody staying one more day goes from a 0% rate to a 40% rate. I think that would be a mistake. So you'd need to do something smoother. For capital gains tax, I think I'm probably most in favour of the Canadian style regime, which is that you don't tax any gains that people make before they've arrived, even if they don't realise the gains for 5 years when they're here. I think the gains they made before they arrived are not really any of our business, and we shouldn't be taxing them. So I think you want a rebasing on arrival. And then the counterpart to that is that, if they spend 25 years here and then leave, you probably want to have a deemed disposal on departure so that people can't come here, make all those gains, but then leave and not pay tax on the gains they made in the period that they were here. For income tax, the real question, and it sort of comes up in this third bullet, is who are we trying to attract? We have to decide if we're trying to design a regime that's particularly attractive to workers. Do we want a regime that's particularly attractive to high wealth people who are coming here, which is sort of more how the current regime is set up? What is it that we're trying to achieve with this regime? And in fact, do we want a regime at all beyond being neutral? So a neutral regime is one in which we neither give you a kind of tax advantage nor a kind of special tax cost for coming here. So we don't want a special cost where you arrive and you have to suddenly pay capital gains tax on the last 20 years of gains that you made, but we don't necessarily have to be more generous than that. If we want to be more generous, I think we definitely need to know who it is we're trying to attract. And I think, just to end up, I want to stress the point that both Emma and Nimesh made, which is, if we're going to design a regime and it's going to be successful, whatever it looks like, it has to be one over which there's some amount of political consensus. Because if we decide, next year that we want to have a regime that attracts one group of people, and then in 5 years' time or 10 years' time, we reform the regime again with a different kind of group that we're attracting, I think that makes a very unstable regime, and one that then ultimately won't attract people because they won't have any certainty over whether this regime will last for the period of time they expect to be in the UK. So with that, I'll stop and I'll hand over to Jane.
Thanks. Thanks, everyone. I'm going to try and share my screen. I've got some slides to show. So hello, I'm Jane Page. I'm a tax advisor and I formerly worked at HM Treasury on this kind of area, non-doms and residents. So I've given this matter quite a bit of thought over the years. I think there are two parts to this debate, and they're quite distinct. The first is the generosity of any relief. So do we have something that lasts for 2 years, 4 years, 15 years, as we currently do? And then entirely separately, there's the design of the relief that we have. What does it look like? Who benefits? So it's important to keep those two parts separate, and I'll sort of cover that as we go through the discussion. Initially, some thoughts on the current regime. It has some benefits. It's very useful for people who are coming into the UK to be able to say to them, don't worry about UK tax. You can just leave things offshore. You don't even need to report it. That's a great tax regime for people initially. Let's be honest, somebody who comes into the UK, their financial affairs will look quite different to mine. They may be quite transient. They'll have ongoing links to another country. It's entirely appropriate that it's going to take them a little while to adjust to the UK tax system. The difficulties with the regime, though, are they've been well documented by the previous speakers, so I won't retread the ground, but the regime does quickly become very difficult for people to use. And certainly people who stay here for a long time find that they end up having to detail with these very intricate rules about what money is in which bank account and where they can spend money without creating a tax charge that they wouldn't otherwise have had to pay. So things quickly get very difficult. There are also, there's the obvious incentive of encouraging people to leave their money abroad. I think that probably it contributes towards us having a culture where we view offshore transactions as being a bit dodgy, even when for lots of these people they are entirely legitimate. And the complexity of the regime, I think it means that, when you read about residence and domicile in the press, the details are often wrong because it's so complex the people writing articles can't hope to understand it. That suggests there are some problems here. Let's be frank, this regime was initially created in the sort of 19th century. So, probably could do with an update now. But change is really difficult. So Arun's talked about the fact that data is difficult. You're looking at offshore transactions that don't need to be reported to HMRC. So by its very nature, any estimate of the tax at stake here can only be an estimate. But also, you're trying to build in a behavioural response, which is trying to predict how people will react to any tax changes. Are they going to move abroad? Are they going to take their money elsewhere? Are they going to stop working entirely? You're trying to predict the future, and obviously that's close to impossible. And that's one of the reasons why a few years ago, the Shadow Chancellor, Ed Balls, said that he was concerned that scrapping the rule entirely would cost Britain money. There are also difficulties when you try and compare the UK's tax system to other countries. So, it's not enough to say, well, people will just leave the UK. You would want to say, well, where are they going to go and why will they go there? Other tax systems are not just, they don't just have different regimes for non-doms. No one else has a system that's quite the same as the UK. As Arun said, most systems are based on residence, but they will also give very different types of tax breaks. But I think you have to look more widely than just the special regime for newcomers. You have to look at the wider tax regime. So, what's the top rate of tax? And when does that kick in? Does it apply when you've got £50,000 worth of income or 200,000? That's going to be very material. You would also need to look at the corporate tax rate, inheritance tax, but also, tax isn't everything. So there are other reasons why people move from one country to another. There might be rules around visas. There's the wider business environment, whether or not a country has financial services. Some people will come to the UK because it has great restaurants and an art scene. The UK has lots of attractions, and the tax system and the special regime for non-doms is just a small part of that wider picture. So, you can look at like-by-like comparisons. You can pick a straw man to illustrate whatever point you want to prove, but it doesn't mean you'll understand the impacts of anything at all. So, there are lots of decisions that bear into people's thoughts about migrating from one country to another. And the more you look at it, the more you realise that you can't compare like with like here. And that what you design as a tax system really has to depend on who it is you want to attract here, and that you can't overlook the other taxes either. So it's a balance. The UK can't hope to compete with every single country on tax. There are countries that have zero tax, and yet not everyone moves to live there. So we have different things to offer. And it's a balance. There's a fundamental trade-off between the fairness and then encouraging investment and being competitive. So looking at how we judge the impacts of the tax system, I found it helpful to group the non-dom population into different segments. And Arun's talked a little bit about the different people that we see. So in my mind, very simple categorization, there are three different groups. You've got employees. So this probably makes up the largest number of non-doms. This is the group who tend, the statistics show, to stay here for the shortest period of time. So employees often stay here for 3, 5, 7 years, a fairly short period of time. This is the largest group, and relative to other non-doms, probably not the highest earners. Employees are the groups who are maybe they're more mobile, but they are also dependent on their employer, so perhaps less likely to move as a result of any tax changes. The second group, which is smaller in number, but possibly higher income are those who work in financial services, so the city. So these are perhaps hedge funders, private equity, etc. So it's a different group, very concentrated in financial services, the city and London in particular. And then the third group, which is probably smaller still, is your high net worth individuals, people living off trust funds, company owners, etc. And this group are possibly, and this is just instinct, but this group is probably more likely to react to tax changes. But also they're the group who tend to stay here the longest. But being very high net worth, this is the group who may have homes in multiple locations, and they might find it easier to become non-resident for tax purposes without making a very significant change to their lifestyle. So if I have a home in Monaco and a home in the UK and a couple of other homes, I can change my pattern of time spent in the UK quite easily and look as if I'm non-resident on paper without actually changing my lifestyle and potentially without changing my economic footprint very significantly either. So the different characteristics of people help you to understand a little about how they would respond and how important the tax system is to them, and indeed whether they actually have much of a choice about whether they can move outside of the UK or not. Critically, any analysis of change to the tax system would need to consider whether reform would lead to people leaving the UK, or whether it would lead to people remaining in the UK but not reporting as UK domiciled. So sometimes we see statistics that show fewer people claiming non-dom status. That doesn't mean, though, that everyone's become a non-resident. We would also want to think about whether reform might lead to decision makers leaving the UK, and whether it could lead to people not coming here who otherwise might have come to the UK. In turn, whether that would lead to lower inward investment. And Arun touched on the point, do people who are non-resident in the UK invest in the UK and generate economic activity here? Is there a group of people who could look as if they've become non-resident, but who continue to invest and generate economic activity here? So there's a fine line between being resident and being not resident for some people, which is probably worth exploring, because it may be that people respond to tax changes, but actually their economic footprint, so the businesses that they own and the investments that they take, don't change. So your key concern when you're considering reform is that you might only lose 200 people, but that within those 200 are a handful of really key people who might take their investment, their company headquarters with them. But setting aside the difficulty of how people will respond, announcements are as much about the messaging as they are about the small print. It's about the overall picture. So potentially a government could do a giveaway which benefited one group, and then, reform a part of the tax system which impacted that same group. And, overall, if the message is still that, the UK is open for business, the UK is competitive, the UK is a dynamic country, then, you don't then lead to this sort of flight abroad. I think it would be possible to reform the system and improve it for the vast majority of people, and raise money as well. But, that there's definitely judgments there, and who wins, who loses, and how they react is key to all of this. So, others have sort of given some initial thoughts about how you might change the tax system. My two pennies worth is that I would certainly lose any reference to domicile, because I don't think that's a fit for purpose definition to hang such a generous tax relief on. I would also want to not have people taxed on remittances. Again, it's just a historical accident that we do things that way. It's not how you would design a tax system today. So I think you would then be looking at some kind of short-term regime which looked at the statutory residence test. So it's an objective test. You've been here, and these are obviously all scalable. You've been here for X number of years. You were non-resident for Y number of years. Therefore, you benefit for this tax regime for a certain period. And then, the question remains, what do you do with the non-UK income gains? Do you tax them at a lower rate, or do you not tax them at all? Or do you not tax them but ensure they're reported here? Potentially, you would ask people to show a foreign tax return to demonstrate that they are paying tax in other countries. That there are lots of sort of smaller decisions that you can make that will design a tax system that would be fit for purpose, but broadly that kind of improvement would do away with a lot of the subjectivity that we have in our current regime and the economic incentives that it currently has by modernising the tax system and bringing it more into something that's fit for purpose and that we would design from scratch today, rather than living with what sort of developed several centuries ago. Noting though that you design around who it is you want to attract. So if you're looking for a tax regime to attract employees, you might design something that looked quite different than the tax regime you'd design if you were looking to attract investors or entrepreneurs. So you need to start with what it is you want to deliver and then design a tax system around that. So that's for me. Just some final thoughts. The complexities around non-resident trusts and inheritance tax. We would need another hour to cover those. So we're not able to go into them today. But those are the sort of parts that would then need some careful thought and consultation with experts before launching into anything. This is a topic that polarizes opinion, but there are benefits to having a regime that is open and attractive to people. It just needs perhaps a bit of updating. Thank you very much. With that, I shall pass back over to Helen.
Wonderful. Thank you very much to all of our speakers. That was fascinating. So if all of our other panelists can pop up on their videos, we'll now have our Q&A. Thank you very much. So what I'd like to start with is basically the point that Jane just ended on, and the question that I think ran through all 4 talks and that I wrote down on my first set of notes, which is, what do we want to do here? Who is it we are trying to attract to the UK? Because as Jane said, I think that's the first step in working out what kind of regime we want to have. And I think, as Emma said very clearly right at the start, we have a regime currently that is more geared towards wealthy people, but other countries have regimes that are geared towards attracting people who want to earn in a country. So I think we have questions here, not simply about how do we modify the current regime, but how do we want to do things more broadly, potentially, for different groups of people. And as I think, Jane and Arun also very, very clear, what you'll do will affect different types of people differently. So we have to think not just over what's the overall effect, but how might we affect wealthy people or employees and so on. That question also underlies the huge number of questions we've got on Slido. I can tell you all that this is a record-breaking event for the CIOT IFS debate. There are hundreds and hundreds of people out there, so thank you for joining us. So let's start with, what are we trying to do here? And let's have a little discussion about the wealthy versus workers as just a shorthand for thinking about different groups. To give you a flavour of some questions on Slido, although there are very many, the top question from Steve Wade is, shouldn't overseas workday relief be reformed so that assignees are encouraged to spend earnings in the UK rather than keep them offshore? Second question is, what measures could Labour introduce to retrain or attract wealthy individuals? I'm going to group a lot of these questions together and basically ask the panel, and I'll come to Emma first. Do we want to attract wealthy people? Are we, as in kind of Arun's language, just trying to not discourage them, or do we want to actively encourage them? And actually, can we even hope to design a regime that does those things differently, like actively encourage the right kind of wealth in Nimesh's language, or the key people, as Jane referred to? Can we really fine tune this system here to try and get whatever wealthy people we think we want in the UK? Emma.
I'm not a great fan of targeting particular types of wealth or even particular types of workers. I mean, certainly France and Netherlands very much do have a targeted relief to say that when you actually become an employee in certain industries in their country, you get a particular tax break, so you get exemption from your earnings. Italy obviously do something different. They attract both wealthy people, so you're allowed to pay 100,000 and then you can bring in whatever you like. And they also have a separate regime for workers there. I wouldn't go for something as complicated as Italy, but I think we've all moved towards saying domicile's not a great idea. Maybe we should go for some sort of phased relief for people who haven't been in the country for some time previously in the UK. They come to the UK, and then maybe for the first few years, however many is a matter of debate, you get some phasing in on inheritance tax, which helps wealthy people, arguably, obviously more than workers. And then it's really a question of, do you want to give any sort of exemption for people who come here on their earnings for the first few years? And it's quite expensive to do that because, as Arun says, they are high earners, but it is something that other regimes do. France has a regime where they don't tax overseas earnings, and they have a bonus system, which in fact I think is now continuing for 9 years. But you have to be an employee in that country. I would probably go for some sort of limited exemption on workers for the first few years, but phase it out fairly quickly after 4 or 5 years. Inheritance tax needs to be longer.
Great, thank you. So Nimesh, can I come to you on a similar question? You mentioned needing to get the right wealth in the UK, but I think you also touched on how the business income relief maybe hasn't been as popular or as used as it could be. So in your view, if we had a phased approach, kind of the one that Emma described, is that the right pathway towards getting the right kind of wealth, or do we need something different? What do you think?
Yeah, I think it's, I would echo the words pathway and phasing. We definitely need this to not be a cliff edge. I think that has created quite a bit of uncertainty in the community and delaying decisions for people who want to come into the UK for various reasons or invest in the UK for various reasons as well. So I think having that roadmap over the next few years, because this would be a big change if we're abolishing it completely. I think it also needs to be linked in with what our corporate investment regime should look like as well, about attracting the right investment into the UK, right FDI into the UK as well. And there's a link in with the immigration rules and the visa rules as well. The investor visa regime, which was a popular route for wealthy non-doms, ultra high net worths to come in. We don't have an equivalent of that for some years now. So how could the various legislative provisions around immigration, investment into the UK FDI and tax all link in together? But I would completely agree with Emma on inheritance tax as well, that we do need something that isn't, again, a cliff edge, because our 40% headline rate is a big deterrent for bringing money for relocation into the UK. I would stress again what I said in my part of the talk is we need to really simplify the remittance rules, or actually ideally do away with them completely, and then have some other form of more broader incentive, which would be universal for UK res and non-doms. We already have a very generous EIS VCT type regime. What more could we do to broaden the scope of those incentives? So it's not just business investment relief. If we can just do away with the remittance rules, there is an incentive for both non-res and UK res and non-doms to bring money into the UK for, say, that right investment that I think the country desperately needs.
Can I just say that on inheritance tax, I don't think you want an incentive for inheritance tax. What you just don't want is a deterrent. We're not saying that wealthy people should be given some necessarily particular form of break, although they are at the moment. We're really saying we don't want them to be subject to worldwide inheritance tax 6 months after they arrive here just because they happen to die here. That does seem to me not a sensible policy. And we have no one's mentioned really trusts, except to say it's all very difficult. But of course, when we're talking about wealthy people, we are going to have to work out a regime for trusts if we abolish non-dom status, because that is how wealthy people will put their money in. And if we don't work that out, we won't succeed in designing a very good regime.
I'm going to come back to trust, because I think I do want to let everyone hear Emma's the 101 on trusts. But just to kind of pick up on some of the points there, I think everyone here has agreed that inheritance tax is different. Some kind of phased approach to inheritance tax is probably the way to go. Do any of my 4 panelists want to disagree with that as a kind of a conclusion? Okay, there you go. We've got a conclusion. Inheritance tax, phased approach. I also want to pick up on some Nimesh's kind of description of different incentives. I think, of course, all these things matters, the visa approach, all that kind of stuff. But as I was listening to you, I thought, that's all sounding a bit complicated. So is there a tension here between having a targeted set of reliefs, but maybe a more complicated regime, whereas what Jane was saying was that at least the current system is kind of simple? I mean, is that a tension, or actually can we get around that through well-designed reliefs? I guess I'll come to Nimesh first, and then I'll go to Jane on that.
Very quickly, and love to hear sort of Jane's more thoughts on this, is that I'm not sure it is that simple right now, given we have business investment relief, release for corporates investing, release for individuals investing as well. It's viciously complicated. Keeps me in a job, but incredibly complicated to understand and navigate which type of relief someone should go and access in terms of the investment that they do. And let's be honest, that creates behavioural distortions here. I would much favour, as I said, a more universal corporate and individual incentive and relief regime, irrespective of your residency and domicile status. But I'd love to hear from Jane.
Yeah, so Jem,
No,
I was sorry, go.
Sorry, I agree. The remittance basis sounds deceptively simple at first, but it's once people have lived here for a while and started to accumulate a pot of foreign income and gains that they would have to pay tax on when remitted, the rules get really complicated. My favourite is the example of the car, which is that if I were to give a car to my grandchild who lives in France, say, and at some point they drive that car into the UK, I then have to report that as a remittance on my tax return. And that, I think, illustrates why the current system is probably not fit for purpose.
Yeah, it doesn't sound like a great system, does it? Arun, can I come to you and sort of moving more to now thinking a bit about workers? So I think you showed us some nice data that a lot of the people, actually this was Jane's first group as well, employees, and then group two is kind of like particularly the finance people. I think often there is a lot of concern here about do we want to not discourage them? Do we want to attract them? So perhaps you can say a little bit about what we know from research, including your own, on how mobile are these people, and how do we, as we talked about, how do we think about them? Because they're in finance, there's a reason to be in London. Do we really need to concern that they're going to run away? You know, what do we know here? If you could talk about that, would be great.
I think the thing that's in a way interesting is when we end up having this conversation about, you know, what's the role of finance and what should we do for that group? I mean, that's the group for whom we're not actually giving them very much at the moment in terms of special deals, right? A lot of them are making use of this non-dom regime, but actually they're not the ones who are the highest wealth people among that use. They have enough income that it's worth it for them, foreign income and gains, that it's worth it for them to make use of this regime. But actually it's not a huge regime, a huge impact for that many of them. The thing that's really important here is that if you were to extend something that just covered all recent arrivals in finance, that would be huge, or even in employees in general, that would be hugely expensive. So more than 25% of people in the top 1% are migrants. More than 40% are migrants if you go to the top 500 people, the top 0.001. So it's a really kind of fast rising group. And so if you start creating new regimes for them, I'm not saying you definitely shouldn't, but if we were to say we want more than just getting rid of this current regime, but we want to actively encourage them beyond what we do right now, that would be definitely an expensive thing to do. The other thing to say about finance is that, kind of as you touched on, finance is an industry that the UK is very good at already. We have a really strong hub in London in a way that just isn't true of many other places. I mean, New York is basically the other place that you would sort of look to like that. And so what we know is that a lot of people move to the UK specifically to work in finance because they'll get paid better here than they do being paid working in Paris or in Frankfurt, even the other financial centres in Europe. And so what that means is that actually the kind of need to offer special tax breaks isn't that high, because as Jane said, it's not what people are looking at is not, well, what's the tax rate? What they're looking at is how much money do I get at the end of the day? And if the answer is, well, I get paid a lot more here, but the tax rate is this or that. If at the end of the day I take away more, my promotion prospects are faster because it's where the headquarters of the bank is or whatever it is. Those are all the things that actually matter more. And so in the end, I think we don't, it's not obvious certainly that we need to add some special regime, given that we're already very good at encouraging people. We certainly don't want to discourage them by, as we said, this discussion around inheritance tax and so on. But I don't think there's an obviously strong case that we need to do some special encouragement.
Right. Thank you. So there's a couple of questions here that we should do quickly, but just to help people out, Arun, about the kind of data we have on, so I just moved on me, on non-dom. So basically, how do we know about how much income they have and what do we see? So perhaps if you can just tell us very quickly how we know about the income of non-doms, and then just to give Jane, I'm going to come to Jane to ask you basically, I mean, we clearly, as you mentioned, policymakers are going to have to make judgments about who is winning and who is losing, and are the right kinds of people winning and losing. If you could just reflect on the evidence base there, and is it good enough, and how do we make these decisions in practice? I mean, if we're looking at a regime that is going to affect a few hundred people, how do we make those decisions kind of in practice on the ground? But Arun, first, just a quick word on how do we know about these people in data?
Yeah, so as was mentioned already, one of the advantages of the current regime is you don't even have to report your foreign income and gains. So how did we learn about them? Well, what we did was to compare people who are users of the non-dom regime to people who don't have access to that regime, but work in the same companies, have the same sort of age, live in the houses in the very same local area with the same kind of house price, are very similar on all these other characteristics. So you compare those two groups and say, okay, well, given that they're very similar in all these ways, we can look at what their investments are. What do we see as the investment income for both of them? Now, for the UK people, we see their worldwide investment. For the non-doms, we only see the UK investment. And so assuming those people behave similarly in other ways, and so will have chosen to make the same kind of savings decisions and investment decisions. But of course, if you're a non-dom, you'll have chosen to make those overseas. The gap between what we see for the non-doms and for the UK people is the bit that we think of as being overseas. And so that's what we're kind of showing there when we show that unreported number.
Great, thank you. So Jane, give us a sense of when you're in the ground, I mean, not to give away secrets, but when you're on the ground and you're trying to make policy for this group, and you know that expecting very small numbers of people about which we have imperfect data, I mean, how do you do that?
So you know, Arun and his team have contributed to the evidence base here, so that's really helpful. HMRC have teams of experts who will do costings for any measure that we're working on as part of a budget or an autumn statement. But to be truthful, any time you ask HMRC, well, you know, what's this going to raise and who's it going to affect, the answer is always that there's got to be some guesswork in there, informed guesswork, but they can't magically always know how people will respond. So any decision that's made will always have a degree of caution. And, you know, we learn from what's happened and build on that. Ultimately, though, ministers have to make the decisions, and they do so always based on an imperfect view, and they do their best to take decisions in the round. So, you know, how much do I need the money from this? What's the economy looking like at the moment? What's the risks? What are the disadvantages? How resilient does the economy see? They will make the decisions as best they can.
Great, thank you. So one more question before I move on to another issue, just a bit on this mobility of workers and trying to draw out where there's agreement or disagreement between the panel. I think I heard, and tell me if I'm putting words into your mouth, I think I heard Arun is basically saying there's not obviously a great case for trying to encourage workers, don't discourage, but don't encourage. Whereas I think I heard Emma saying maybe there is a case for some limited time regime to encourage certain kinds of workers. So I guess to Emma, is that a fair reflection of your position? Do you sort of disagree with Arun a little bit here? Maybe Emma has a stronger case for that. And then to Nimesh, where do you fall down on what should we be doing about mobile workers? So Emma first, please.
Yeah, I think there's certainly worth thinking about that for people who come to the UK as employees, do you want to give them any exemptions at all, whether on their employed income or on their income and gains, investment income and gains for the first few years? And the reason for that is simply that is what other countries do in Europe, and we are competing with them. I take on board Arun's point about the finance industry and banking, but obviously that's why France partly has introduced this regime, because they want to encourage bankers to move there. I think Germany is the one outlier in this. It doesn't have any incentives, as far as I can make out, for impatriates. But almost all the other European countries, perhaps less transparently in some cases, have some sort of exemption. I do accept, though, it is being phased out a bit now. So the exemptions are slightly less generous in these countries, apart possibly from France than they used to be.
Okay. And Nimesh, where do you fall down on this? Would you have an incentive for high-skilled, high-earning bankers and other workers?
I don't think it'd be targeted. I think the overseas workdays relief is actually simple. The problem is the remittance basis again. And I would question, and I don't know, maybe Arun has some insight, but I would actually question how many workers do use overseas workdays relief. You do need quite accurate structuring with your bank account to actually take advantage of that. And also some perceived high earners may not want to actually use overseas workdays relief because they want the money in the UK. We should also think about the fact that the employer is paying employers' national insurance as well. I would also just think about, and this is maybe more of a short-term economic impact that we have in this country right now, which is we do have a labour shortage in quite a lot of areas. I know we're not talking restaurants and bars, we're talking the finance sector in specifically, which I know Arun has spent a lot of time on. But in my industry as well, in accountancy, we have suffered a labour shortage over the last 3 years. So, whether it's not an incentive for the employer, but to attract those skilled workers into the UK, for us to have the choice to be able to employ them, I don't think is a bad thing. I would again do away with the remittance basis point around that, though, to make it more simpler.
But can I just say the overseas workday relief is really complicated. You have to be foreign domiciled. You have to work abroad to get it, and you can't remit it. I mean, the other countries have a much easier relief. You haven't been resident there for 10 years. You come to France or wherever, and you're an employee there. That's the key thing. And you get a percentage of your income exempt for a certain level of time. Seems to me quite a good regime.
I think the regime is simple. The operational side is complicated. I still would have an element of what is the proportion, what's the right proportion of taxation, and actually overseas working does seem reasonable. There might be a better way to do it, as you say, Emma.
So I think my takeaway is that this is a really important area, but we haven't got agreement on our panel. It's exactly what you do with foreign workers. But as Arun said, they are, sorry.
Yeah, just the one thing to pick up back on something Nimesh said earlier, which I think is really important here, is also we shouldn't look at tax in a vacuum here. I mean, the point about visas and the other parts of the regime are really important. So people are making a choice over a whole set of things, and we shouldn't just get fixated on tax because it's, obviously CIOT, IFS, but we should remember those other things really matter as well.
Yeah, absolutely. We often say IFS don't always use tax. There are other instruments available. Right, I want to tackle trusts, Emma. There are loads of questions on Slido about trust. I'm not going to read them all out. Some of them are too technical that I don't even necessarily understand them. But they've been mentioned in passing a few times. To give you one example, Mark, top question, has asked, what is the panel's view on availability of excluded property trusts? So Emma, could you give us the kind of simplest version possible of like, what's going on with trusts here? Why are they important? I noted that Nimesh said that they can still be used for tax planning for non-doms. I think many people have a view that they're kind of this murky structure that are just tax avoidance structures. So what is the big issue with trusts? What do policymakers need to be considering when they're thinking about this regime as it applies to trusts? Help us out.
Okay, I'll do inheritance tax first because that's probably the easiest and probably the most important. So you're a foreign dom, you come to the UK, you're coming into your 14th year of UK residence, and you think, oh, in a couple of years I'm going to be deemed dom. And when I do that, I'm going to pay inheritance tax on my worldwide estate. So you put all your foreign assets, and they can only be foreign assets, into a trust. And you could become deemed domiciled. You may even become actually domiciled. And those assets are permanently protected from inheritance tax. You can put UK assets into the trust as long as you've got a foreign holding company above it. So it's sort of like an umbrella. The only thing it won't protect really is residential property in the UK and certain types of loans. But it's the trust, we call it an excluded property trust regime. So once you're in it, once you've got your settlor who's foreign domiciled, who's put all those assets into the trust, then essentially it is protected from inheritance tax forever, provided the trust has foreign assets or a holding company with the UK assets underneath. So that's inheritance tax. Capital gains tax and income tax are unfortunately more complicated. The income and gains, if you put them into a trust when you were foreign domiciled, and the income and gains can be rolled up tax-free in the trust broadly. There are quite a few exceptions to that, which are catching people out, foreign doms out. So to certain types of accrued income, UK source income isn't protected, but basically sort of foreign dividends can be rolled up in the trust tax-free. If they're ever taken out of the trust by the foreign dom, then they're taxed at that point. However, the trust has to be non-resident, and you mustn't what we call taint the trust. So you must never add to it after you've become deemed domiciled. And the other key thing, which is causing a lot of compliance problems, is that the foreign dom must continue to remain foreign dom as a matter of general law. So they've got to continue for the rest of their life, if they're in the UK and they're staying here for longer than 15 years, they're deemed dom for tax purposes, but they've also got to show they really do intend at some point to leave. And that's what causes a lot of compliance problems. As the Revenue quite rightly say, you've been here 15, 16, 17 years, when are you actually going to leave? And it raises the stakes for everybody, because if the Revenue can show that you are UK domiciled here, then all the income and gains of that trust get taxed on you. And so it's I think originally in 17, it was introduced to try and simplify things, but in a funny way, it's actually complicated them, and it is a regime that needs looking at, I think.
So can I just ask on the IHT one, which you say simpler, when we were talking before about the phasing approach of IHT, bringing people slowly into the regime, which I think all of you agreed on was a good approach, how would that, if at all, how would that apply to trusts? Can we apply that to trusts in a way that's not complicated?
You'd have to have a different regime, because domicile is, at the moment, our entire connecting factor for IHT. Residence doesn't, in a sense, matter. So you would have to have some regime that says, and then it gets quite complicated. There are options, but you might not want to hear them. And you've also, by the way, got to think about transitionals. So what happens to all these people who did set up their trusts when they were foreign dom, thinking they'd be excluded from inheritance tax evermore, and now we abolish foreign dom? Do they go on being excluded from inheritance tax, or do we bring them into the new regime, whatever that is? Or do we say that if the settlor is resident here, as long as he's resident here, the trust is now subject to inheritance tax, but if he leaves, he's not? So you've got to think about all these sorts of areas.
And I realize this is a naive question, but am I right in thinking that at the moment this must be quite a popular, well, I assume this is kind of a popular thing to do for very wealthy people, and it would get more popular if you had an approach that brought people more quickly into inheritance tax. This seems like a leaky back door to whatever we're talking about here, that if you don't fix trusts, well, I'm saying fixed, knowing that's not really fixed, but if you don't deal with trusts, then actually you could potentially undermine a lot of your regime. Am I right in saying that, Emma?
Well, if you abolish domicile, you'd have to think about a new connecting factor. And if you said, well, if you're resident in the UK for more than 10 years, let's say you can't set up a trust that's excluded, obviously it will be a leaky back door. I'd be very surprised if any regime that said once you're here 10 years, you pay inheritance tax on a worldwide basis, if you're resident here, then allowed trusts to escape. But you would have to deal with them specifically. And it's not always easy to see how to deal with it. Other countries have different regimes. And the US and the Irish actually are quite interesting regimes because they're both common law countries and they follow a slightly different path. So we should certainly be having a look at those regimes.
Right, thank you. Nimesh, did you want to come in on trusts?
When as I said in my part, trusts were dead for probably about 3 months in 2007-8, and there was a reversal, which I still don't know why, but maybe the rest of the panel can enlighten me as to why that change was made at the very last minute in 2008. And in 2017, essentially what happened, and just picking up on Emma's comment that you need to maintain your foreign domicile in order for the trust to remain protected. I suppose this was a backway mechanism for the government and HMRC to continue to have an indefinite non-dom regime. And we wouldn't have maybe been in the situation that we are in right now with trusts and the 17 rewrite had Ed Miliband and the Labour opposition not been so forthright in their view that they would completely abolish the non-dom regime. In that 2015 election, the Conservatives had to react. Their reaction was introducing a 15-year cap, but then also introducing, as Emma was saying, a more complicated set of offshore trust rules, albeit with the right structuring can be quite generous. I think it's really difficult. And if I go back to 2008, I wonder if there was quite severe lobbying from the trust industry as to why we then have that reversal to put trusts, to still make trusts useful in 2008. I don't know what the financial and political and social push is on to maintain that trust regime, because if we did have another 2007-8 repeat where trust was dead, that industry would completely collapse. It's going to be complicated around the transitional rules as well. I feel right now we're not going to solve it in the next 10 minutes. It's in the too difficult column.
Okay. So I'm going to try to do sort of 3 quick fiery questions because we're coming up against the time. I mean, that all sounds horrendously complicated. Given that, how Labour have said they want to change this regime, how quickly should we expect to be able to see change? So should we expect to say actually Labour comes in and can quite quickly do something but park trusts? Or should we be thinking actually this is a really big complicated area, uncertainties, problematic, think about it for a while, get a regime sorted and do it near the end of the Parliament? How quickly should we think about seeing change? I'll do a quick fire, Emma, and then around.
I think if you're going to do anything, you need to do it fairly quickly, and hopefully they'll think about it before they've had time to do it. I think leaving it will only complicate the regime. There'll just be more lobbying and more difficulties. And actually, that's what happened in 2017. It was announced in 15, came into effect in 2017, and I don't think one could honestly say it had improved in those 2 years.
Right. Anyone else want to disagree with that?
Yeah, I would disagree with that, partly for what I said in my comments, that this is such a massive opportunity. The debate that we're having right now is proof that actually this is an opportunity for the UK to really reset its regime on a number of levels. I think you rush it. If you rush it politically, socially, you end up with more problems again and not a fit for purpose regime for the future. This should be left alone after this. So I would say, look, the earliest that anyone should be making any legislative changes would be 2027 for me. I think there's a long period of consultation. There's people like us, the IFS, CIOT, that should be inputting into that to really get a fit for purpose regime.
Jane, do you want to jump in on that?
I would echo the need for consultation. Absolutely. I think it's really difficult to get this right when you've just got politicians working on their own, particularly since until any new government is elected, they will not have the support of HMRC and other experts. So they will need, they can do the pre-work, but they will need also to work with HMRC once a newer government is formed and to take the views of experts through the consultation process. Okay,
Arun, do you want to say anything on that?
I was going to say, I think I agree with Emma that it's really important that, and I hope they're doing some ground, that if Labour Party are going to be promising this going into the election, that they're doing some groundwork now. I think it's right, as Jane says, you will need to work with the civil service to actually work out how to implement this. But as I think we've all highlighted, there are some like big policy choices of just like, what do we want the regime to look like, big picture, like who we are trying to attract, what we're trying to achieve. And those decisions, hopefully, they are thinking about and making now, so that if they were to win the election, they're able to then quite quickly get on with the bit that's now like, how do you implement that, rather than at that point thinking, what is it we're even trying to do? Because that would be a real mistake, I think.
Great. So I should draw it to a close. So I can see we've hit the end of our time, sadly, because I could carry on doing this. I think we got some agreement here that the non-dom regime needs to change. I think we had some points of agreement, including on phasing IHT, or maybe actually getting rid of domicile as an idea, but obviously still big issues to work out. But I heard loads of ideas today for how we can actually make progress here. So I'm hopeful that we can do something better. Let me thank all of our speakers. I think chairs always feel obliged to say that was fantastic. I think that really was fantastic. I had a really good time listening to all of that. So thank you very much for joining us. And thank you to the hundreds of people out there who listened in. I hope you enjoyed that too. Thank you.